everyone, welcome to yet another exciting episode of Media Voices on Prince Media Television. Earlier today, a number of judges were delivering a judgment regarding the trial of Ugandans in military courts. Here are the few things they highlighted in their video.
The General Court Martial, though lawfully set up by an Act of Parliament, deriving such powers from Article 129 1D of the Constitution, is in its present form competent only to handle matters relating to discipline of members of the armed forces.
I would declare that Section 197 of the UPDF Act, which establishes the General Court Martial, is not in breach of the Constitution. When the UPDF Act creates an offense that targets persons not otherwise subject to military law, making them criminally liable before the court martials for offenses of aiding and abetting. For creating such vulnerability, I would declare Section 117, which it is now, and Section 1171H, 1177 of the UPDA Act unconstitutional. I would set aside the decision of the Constitutional Court in this regard. I find Sections 1, Section 177, and Sections 1171G of the UPDA Act in its current form unconstitutional. I uphold the decision of the Constitutional Court to the effect that the General Court Martial is a constitutionally established court set up to handle cases of military discipline for UPDF members, but lacks jurisdiction to try civilians for offenses under the Penal Code or other enactments. I would declare that the arrest, detention, prosecution before the courts martial of the cross-appellant respondent and civilians of equivalence under Section 1191G, read 1171G, is in breach of Articles 21, 28, and 44 of the Constitution of the Republic of Uganda. For reasons above, I would make the following orders. All convictions and sentences passed by courts martial would be suspended. A pathway would be put in place to ensure that all citizens hitherto convicted and sentenced by the military courts martial have their convictions and sentences subjected to judicial review before a civilian court of competent jurisdiction to determine whether the convict received a fair hearing and impartial prosecution. This order would not apply to persons who were convicted and sentenced by courts martial and have already served their sentences.
I find that the Constitution of the General Court Martial does compromise its independence and impartiality as a subordinate court of unlimited jurisdiction and is to that extent inconsistent with Article 28(1) and 44C of the Constitution. In the result, I would resolve ground 2 of this appeal in the negative. On the other hand, under ground 3 of the appeal, the respondent's arraignment before the General Court Martial is specifically challenged on account of the omission in the charge sheet to indicate his role in aiding and abetting the commission of a service offense as contemplated under Section 117(1)G of the UPDF Act. As was earlier observed herein, a person that aids or abets another in the commission of an offense is deemed to have taken part in the commission of the offense and, if proved, would be guilty of that offense. In the instant case, an incomplete charge sheet was annexed to the affidavit in support of the petition as Annexure A. It reveals that A1 to A8, with whom the respondent was arraigned, were at the time in active military service and therefore automatically subject to military law. The respondent, on the other hand, is depicted as a civilian, a member of the 10th Parliament of the Republic of Uganda, representing Nakawa Division in Kampala District, and designated as a person subject to military law by virtue of Section 119(1)G, 117, that is 117, 117(1)G of the UPDF Act. Under count 1 of the charge sheet, the statement of offense is stated as offenses relating to security, contrary to sections 131F of the UPDF Act, while the particulars of offense indicates that the respondent, together with 22 other named persons and others still at large, between the months of February and June 2016, in diverse places.
For 4 years, and then recently Dr. Kiza Besigye, Haji Obed Lutale, Council Aaron Kiza added to that list. There is no place for a military court to try civilians, and we are glad that has come through very clearly in court. We are glad that the Supreme Court has listened to the voices of Ugandans over time, because the people of Uganda have spoken again and again, and it's important that when people speak, courts get to listen. We are also glad that it's not just civilians that have benefited from this, but even serving military officers. Because a number of them have been persecuted through the General Court Martial, and they had no recourse anywhere they could not appeal. Because you see, the General Court Martial, they are the complainants, then there are the prosecutors, the General Court Martial. They are the ones that sit on the panel, the tribunal, to determine a matter. When you appeal to, again, a team of military fellows. It becomes problematic, and they also execute the same sentences. Yeah? It is problematic in and of every sense. So we are glad that that has been rectified. Our hope is that now this court order will be followed with immediacy. Because many times courts of law issue orders and they are disregarded. People have been freed on bail and they are arrested within court precincts. Many times you've had General Museveni say, you courts, you want to take us back to those days and that kind of thing. Our hope is that the court order will be respected with immediacy. Briefly, Muruganda.